Welcome back to Lunchtime BABLing. My name is Shea Brown. I'm the CEO of BABL AI, a company that audits algorithms for bias, disparate impact, ethical risk, and good governance. So we're back again talking about Local Law 144. I thought that we might be done with this topic. And I thought, in fact, I was going to be done with these webinars for the holiday season, but the Department of Consumer and Worker Protection for New York City dropped some new rules and some new information right before the holidays. So what did they say? So this is going to be a sort of an informal update on what the new information is and what these new rules have proposed. So they announced two major things. One is that the law itself, which was set to be come into effect in a few days from now, so January 1st, has now been pushed back to the 15th of April. Happens to be my birthday, actually. And so that's a significant pushback in time. This is something a lot of people wanted because there was still a lot of ambiguity. The new rules, the proposed rules that they had put in force, which we've talked about a lot here, were not accepted. And there are a huge number of comments, including ones from BABL, about those rules. And so I think wisely they felt that they simply needed more time to get this right. And so it's been pushed back. The enforcement has been pushed back to April 15th. And the other announcement is that they submitted a new set of proposed rules, and there will be a hearing, a public hearing on those rules and more public comments January 23rd. So these are two significant developments. And so what I'd like to do today is talk about what those new rules say, what's different about them. And instead of doing a sort of detailed PowerPoint, which is something that I've done before, I think eventually I will do that. I'm just going to go through these rules and take a look at them, and we'll do it together. And there are a few key things that I want to highlight, some things that I think are significant improvements on the rules. And I think overall, they have been clarified a lot, and there have been significant improvements. There are a couple of areas that I think are worrisome, and so we will for sure be commenting on those when the time comes on January 23rd. So what I'm going to do here, and so as always, if you have questions, go ahead and ask it, and when I'm done, we'll do a Q&A at the end. So let me share my screen here. So let's take a look at these new rules. So instead of doing a PowerPoint, let's just go through them. And so as you can see, the hearing is going to be on January 23rd, the public hearing, and you can submit comments up until that point. And again, the enforcement has been pushed back. It doesn't say it here, but the enforcement has been pushed back until April 15th. So there is some significant time. And this is in a lot of ways good for us, because I think that there are a lot of people that we could have worked with to do these audits that we felt like we just didn't have the time because of the really tight deadline. And so now this opens up possibility for us to work with a lot more people to help them get these audits done. And so here's the statement of the purpose of the rules. They really want to try to clarify things. And we've been over this before, so let's just talk about the proposed amendments. So the one that I've highlighted here, and this is probably the most significant one, so let's just start here. Automated employment decision tool. So they've tried to clarify what an automated employment decision tool. So this is the thing that is in scope for this law. So for those of you who have not listened to some of our other webinars and don't understand what's going on, this is a law that New York City has passed, which will require that tools used for hiring and promotion, AI tools that are used for hiring and promotion, which they call automated employment decision tools, will have to have a bias audit done if employers want to use them within the last year. And the bias audit has to be made public the summary of the bias audit has to be made public. And then there's a bunch of candidate notifications associated with that. You have to let candidates know that this tool is being used, or employees if it's a promotion decision. And there's a lot in the rules about what a bias audit is and what it means. And this is very important for our company because this is what we do. We audit algorithms for bias. So what counts as an automated employment decision tool is there was a lot of ambiguity. And so they've tried to fix that ambiguity. They did it with the last set of rules. And what you're seeing here, and I'll just read it out loud for those who are listening to this, an automated employment decision tool, or an AEDT, means an automated employment decision tool as defined in the original law of the code, where the phrase "to substantially assist or replace discretionary decision-making" means, one, to rely solely on a simplified output, which is like a score, tag, classification, ranking, etc., with no other factors considered. So this is where you only use this simplified output to make to make a decision, like to screen someone out of the process, with no other factors. So that's the only factor that you consider. Two, to use a simplified output as one set of a criteria where the simplified output is weighted more than any other criteria in the set. And so let's say you have many other things that you might consider. So you have an AEDT, which will provide the simplified output, and then you might have other factors that are weighted in a decision, an automated decision, and the AEDT's output would have to be, or this automated decision tool's output would have to be weighted more than everything else in order for it to fall under this law, or to use a simplified output to overrule conclusions derived from other factors, including human decision-making. So this is almost verbatim what was proposed in the last rules, which we commented on. And the only difference is in the third part, it said to use a simplified output to overrule or modify conclusions derived from other factors like human decision-making. And we pointed out that what counts as modified was very unclear, and that in general this is very limited in scope, and the only sort of saving grace was this idea of modify, because basically this is saying this tool has to be the only thing. So if we step back and take a look at these three criteria, essentially the score or modified output has to be the thing that makes a decision whether someone passes through some part of either employment hiring funnel, or whether they get a promotion or something, because they've removed this to modify. And we commented that modified was ill-defined, but and I think other people did as well, but the response seems to have been to remove that. And unfortunately, by removing that takes almost everything out of scope. And so if there's a human that makes a decision at any point in this process, then and this score doesn't overrule that human decision making, then it appears to be out of scope. And so this is something that we're going to comment on. It's worrisome, I think, that they should have just gotten rid of this and actually stuck with the slightly vaguer language of the original law, because you can make an argument for many tools. Almost everything is going to be out of scope the way it's currently written. And that's my opinion. We'll see what other people have to say. We'll make comments on this. Some things that would be in scope still are if there is some automated filtering. So if the score essentially or the modify or the simplified output essentially takes someone out of the process, so it's never displayed to a person, this would still be in scope. So let's say 100 people apply for a job, and an employer or an employment agency will look at those candidates, and there are some subset of those candidates which are not visible at all to the person, making the decision, they get automatically just sort of filtered out because they're below some cutoff, then that I'm pretty sure that would still be in scope. Again, this is not legal advice. You definitely want to talk to your lawyers about this and make sure that that you're very clear about what is in or is not in scope. But in any case, this is significantly limiting the scope by removing that modify. And so this is something that is quite worrisome. Okay, so moving on to some things that we think are better. So a lot of these definitions are, so for those who are listening, I'm scanning through this document. This document is, if you want to get a copy of it, we can put a link to either the YouTube or to the podcast. This is the proposed rules that the Department of Consumer and Worker Protection have just put out right before the holidays. And much of it is the same. One thing which makes us quite happy is they've clarified the idea of an independent auditor. So the bias audit was the actual phrasing of it is a bias audit is an independent evaluation, an impartial evaluation by independent auditor. And they needed to, there was no clarity in the law around what that actually means. And they're open door to lots of different things. And the new proposed rules are the ones that came before this, kind of opened the door to potential internal auditing, meaning you could have someone within the company that that isn't using the tool or isn't involved in making the tool, but it's their job to sort of audit it. And these new rules that just came out would kind of preclude that from happening. So let me read it for those who are just listening. This says an independent auditor means a person or group that is capable of exercising objective and impartial judgment on all issues within the scope of a bias audit of an AEDT. So here they're emphasizing that impartiality and objectivity that needs to happen. An auditor is not an independent auditor of an AEDT if the auditor. So now they're clarifying what does not count as an independent auditor. So one is or was involved in using, developing, or distributing the AEDT. So that means if you're part of the team that was involved in using it, so on the employer side, or developing it, which would be on the vendor side, or distributing it. So if you were part of sort of selling or distributing this. Two, at any point during the bias audit, has an employment relationship with an employer or an employment agency that seeks to use or continue to use the AEDT, or with a vendor that developed or distributes the AEDT. So this is where they sort of kill the idea of an internal audit, because you can't have someone who is has an employment relationship, is getting paid by the employer or the employment agency, or is being paid by the vendor. So you can't be an employee of the vendor or the employer. So it's got to be an independent, well, it has to be a third party, has to be somebody external to those companies. And so that's really good clarification that they actually said that. Three, at any point during the bias audit, has a direct financial interest or a material indirect financial interest in employer or employment agency that seeks to use or continue to use the AEDT, or in a vendor that has developed or distributed the AEDT. So here, they're getting more at the sort of notion of independence that BABL adheres to, which is the for humanity notion of independence, which is borrowed from the Sarbanes-Oxley notion of independence. Although they're not getting into as much detail, they're basically saying you can't be getting paid by the employer employment agency for things other than this audit. Now, they don't exactly say that. They say at any point during the bias audit has a direct financial interest or material indirect financial interest in an employer. So they can't mean, of course, unless they expect people to do these bias audits for free, they can't mean the fees that are for the audit themselves. that's something that maybe we'd need to comment on. I think it probably goes without saying, but that means that probably you can't be doing other services for either the vendor or the employer. So you couldn't be like a contractor for other things, and then they say, hey, come do this audit for us. We're paying you for other stuff too, but come do this audit for us. Because, you know, there's a conflict of interest. You have an interest in sort of pleasing this employer or this vendor because you're getting paid for things other than the audit. Now, it's not exactly clear from this language that that's what they mean. That's something we'll have to ask, but I think it makes the most sense, and it's the thing that we think is what they're getting at. So overall, our thoughts are this is much better. We sort of push for independence during the commenting period both times. So we commented both times when there were proposed rules, and both times we sort of pushed for clarity around independence. We didn't necessarily push for third-party independence, even though that is in our interest because that's what we do. But we did push for clarity, and we're happy that the clarity sort of landed on the side of sort of third-party independent auditing. We think that's a better way to go. It's a more robust way to go. And, you know, we've talked about this many, many times on this podcast. So, okay. So now the impact ratios. Impact ratios, you know, the first proposed rules, which have now been superseded by these that I'm reading here, open the door for using an average score as opposed to a selection rate. So for those who aren't that familiar with how these sort of disparate impact things work, so the bias audit has to test at a minimum for disparate impact. What is disparate impact? Disparate impact really centers around this idea of selection rate. So who gets selected for a job and who doesn't, and at what rate do individual groups categorized by race and ethnicity and gender, because this focuses on just these what are called component one categories, which is gender and race and ethnicity. You know, at what rate do these individual groups get selected? That's typically the way it's done because, you know, people will either hire groups at a higher rate or not. And so that is using selection rate, and an impact ratio is basically the selection rate for a particular category, like it could be male, female, could be different races or ethnicities, divided by the selection rate for the most favored category or group. So whoever had the highest selection rate, you take everybody else's selection rate and divide by that highest one to figure out what the impact ratio is. And if it's below 0.8, that's when there's sort of indication that there might be disparate impact. There's also other things you have to consider as well, but that's sort of the important metric. In the proposed rules before these, they open the door for what is called an average score, because some of these tools are just used to assign a score or some sort of simplified output to people, and not necessarily map directly into selection rate. And so they said, well, you can take the average score and sort of divide it by the highest average score, and that could be the definition of the impact ratio. They have something similar here, but they've replaced that average score with what's called the scoring rate for a category. So that's here, scoring rate for a category. And so if you look down at what the scoring rate is, scoring rate means the rate at which individuals in a category receive a score above the sample's median score, where the score has been calculated by an AEDT. So what that basically means is, let's say so for all of this, in order to calculate these things, you have to have some test data set. You have to have some, well, they call it historical data here, which is essentially a set of data from the AEDT that's been used on actual candidates. And what you would do is you'd say, okay, for you have this whole sample, and then you say, what's the median score for that sample? So median is just the one that's sort of right in the middle. So you find that median score, and the scoring rate means the rate at which individuals in a category receive a score above the sample median. So in that sort of top, not quite 50% well, top 50%, basically. So you'd figure out what percentage was above that median score for each individual category. And that would be the scoring rate for that category. You find the highest one, that would be your favored group. And then to find the impact ratio, you take that scoring rate and you divide it by the highest one. So this is different than the average score. And I think this is a good thing. There are a lot of comments that where the average score is sensitive to the scale at which you are scoring things. So if I'm scoring things on a scale of 1 to 5, for instance, that might be different than scoring it on 1 to 100 or 1 to 10,000. And so those differences, there can be some offset in this ratio when you do it in that way. And so this here, they're essentially attempting to mimic a selection rate. They're saying if you're in the top, if you're above the median score, you're going to be considered to be sort of have a positive outcome. And if you're below that, that would be like a negative outcome. So when we do our audits, we have that stipulation as well, where people who that we're auditing have to make a decision about what is a positive outcome versus a negative outcome, and to basically calculate a selection rate based on that. And here, the department is essentially saying that they're going to set the standard for us in some sense, and say that if it's above the median, then that's a positive outcome. If it's below, that's a negative, and then you can get a sort of quasi selection rate from that. So that's another important thing. And this actually is something that we'll have to modify our audit a little bit to account for that, in fact. But I don't see it as a significant problem. It does make a lot of sense and gets rid of some of the ambiguity or some of the problems with the scaling that they had talked about before. I think a more robust way is the way we do it, in the sense of you let the company define that based on a risk assessment. And because risk assessments are where you need to, in order to make that claim that this is a positive outcome versus a negative outcome, you actually have to look at the way the tool is used and the socio-technical system in a little bit more rigorous way. But I think this is an okay way to define it if they had to. Okay, they talk about the selection rate. So now simplify. Most of this stuff is the same. So things like the selection rate, the simplified output, that all looks fairly good. One thing that was a big question when they proposed the last rules, the ones that have been superseded by these rules, is that they had intersectional categories in there, but they didn't say anything explicitly in the rules about needing to have intersectional categories. So what do I mean by that? Typically, you would, if you were doing some sort of EEOC investigation or analysis to figure out whether there's disparate impact, you would look at these so-called component one categories individually. So that means look at the selection rate, let's say for men, and look at the selection rate for women separately. And you would figure out whether there's disparate impact between those two groups. And you'd look at race and ethnicity, and look, for both male and female at the same time, and look for differences among the race and ethnicity. Intersectionality means you are looking at the individual intersections of those categories. So you'd look at, white women versus, let's say, black men, and everybody, and all the other intersections of that. And so the way they had shown the results on the first time was at this intersectional basis, which is not typically what is done. And a lot of people commented on this. Some people were all for it. I mean, we thought that that's actually was pretty progressive of them to do that, although slightly risky because it does deviate from standard practice. And we just simply asked for some clarification about that. They have clarified it, and it was not a mistake, which I think some people had thought that it just was a mistake. It was very intentional. And so when you calculate these, when you do a bias audit, you need to you need to calculate these impact ratios. And then you need to show them both on a sort of individual basis and then on an intersectional basis. So the calculations required must separately calculate the impact of the AEDT on sex categories separately, race ethnicities categories separately, and then intersectional categories of sex, ethnicity, and race. So, and all of those need to be displayed. And so they are very explicit about this, that that was not a mistake. And these bias audits need to calculate on an intersectional basis. So this was a great clarification. It makes it made it very clear that that's something that they want to see. Okay, so next is this sort of, they give some examples, and so in the examples they're very similar to what they had showed before. And the first example says an employer wants an AEDT to screen resumes and schedule interviews for a job posting. To do so, the employer must ensure the bias audit has been conducted a year prior. So just reminding us, you got to get this bias audit done. And then the employer asks the vendor for a bias audit. So this is the same as last time. And so they're repeating it again, that an employer can ask a vendor for a bias audit. And so it does appear that that is an okay thing to do in some circumstances, and I'll get to that in a second. So the vendor provides historical data. So historical data here is defined as data from the AEDT being actively used by employers. And it says the vendor provides historical data regarding the applicant selection for the vendor that the vendor has collected from multiple employers. So they have multiple employers here to an independent auditor. So they clarify this was not something that was clarified before. They had mentioned multiple employers, which makes it seem like a vendor can use other employers' data when conducting this. Here they explicitly say it needs to be given to an independent auditor, which is great for us, and I think great for people who will conduct a bias audit as follows. And then they show essentially the numbers that you would need to calculate. So if you're just listening to this, it's essentially a table that shows the first part will show the impact ratios for sex categories, the second for race and ethnicity categories individually, and then the intersectional categories. So they show all three of these tables need to be displayed. And it says where an AEDT scores candidates for employment or employees being considered for promotion, the bias audit must set a minimum. And so they have just similar explanation for when you're screening for promotion. It's essentially the same thing. They have another example for culture fit, and so here's they had both these examples in the last rules, and they're repeating them here. This second example is one where they're using the scoring rate. So previously they had showed someone gets a score for a culture fit, and now they're sort of showing that the results have to be for the scoring rate, which is a percentage. And again, it's the percentage in a category above the median for the sample. And so the only difference here is that they're showing this as a percentage. Now, they also don't show the number of candidates, which is something that happened last time. And it also is happening this time when they did the average score last time, and now that they're doing this sort of scoring rate, they're not showing how big the sample size is. I'm not sure if that's necessarily on purpose, because in the other tables they do show number of applicants, number selected, and here they're not showing that. And so in any case, we'll probably comment again to see, just to make sure that that is what they want to do, because it seems like a bit of a mismatch between the two ways of doing it, because in theory you could just put the number of the total numbers as well for the test data set. Okay, so most of that was the same except for the scoring rate. Then comes the data requirements. This is a new section. And so I'm going to read this for those who are listening. A bias audit conducted pursuant to Section 5301 of this chapter must use historical data of the AEDT. So historical data is data that is from the AEDT as it's being used by employers or employment agencies. Okay, so this is live data from the past to test it. Okay, so they're saying explicitly you got to use that historical data. And then they say if insufficient historical data is available to conduct a statistically significant bias audit, test data may be used instead. Test data is data that is other than historical data that can be used to test for bias. So here they're saying that if you don't have enough of that data, then you can use test data instead. And so let's scroll up and just talk. Let me talk or list out what test data is. Here we go. Test data means data used to conduct a bias audit that is not historical data. So they didn't go into much detail there. Those of us who do bias testing sort of know what test data is and what it looks like. So it's okay that they were being a little bit vague there. So part B of the data requirements. If a bias audit uses test data, so now they're saying if you have to use this test data, the summary of results of the bias audit, so this is the part that gets disclosed publicly, must explain why historical data was not used and describe how the test data used was generated and obtained. And so this is a disclosure requirement now. They're saying, okay, if you're not using live data or live historical data from the tool, why? And you can't just have a why. You have to disclose in the public summary why you didn't use the historical data. And so this actually adheres really well to actually all of this adheres really well to our bias audit as we had constructed it last year or late this year. And so we also have a similar requirement. You got to explain why you're not using other data. There are legitimate reasons for it. Either you can't get access to the demographic information, or you're a brand new tool, you haven't used it before, or the way the tool is used is such that you simply can't get access to that historical data through like some agreements with the vendors, like you're not even allowed to get access to that. All right, so part C of the data requirements says a bias audit of an AEDT used by multiple employers. So this is an important one. A bias audit by an AEDT used by multiple employers or employment agencies may use the historical data of any employers or employment agencies that use the AEDT. So here they're saying, let's say you have a vendor that has a tool. The tool is used by many employers or employment agencies. They're saying you can use the historical data from those other tools to do this bias audit. However, an employer or employment agency may rely on a bias audit of an AEDT that uses the historical data of other employers or employment agencies only if it provided historical data from its use of the AEDT to the independent auditor for the bias audit, or it has never used the AEDT. Okay, so let's parse this out a little bit. Essentially, what they're saying is, in the case that they mentioned before, the example they mentioned before, they have an employer and the vendor does the bias audit. So the employer asks the vendor, please do a bias audit for us. The vendor says, okay. The vendor gives data from many employers to the independent auditor who conducts the bias audit. Okay. What this is saying is if an employer is going to rely on that vendor-produced bias audit, that employer has to have contributed data to that audit. So if I'm a company, I'm Walmart or JP Morgan Chase or somebody, whoever might rely on this, right? I use some tool and the vendor who created that tool conducts a bias audit. So they have an independent auditor conduct a bias audit with a bunch of historical data. If I didn't contribute, if me as Walmart, let's say, didn't give any of that data to the or allow for that data to be used for the independent audit, I can't then rely on that audit summary. So if I haven't participated in the process, I'm not going to be able to use that audit, the vendor's audit. of course, you can do your own audit on your own data, but if you're going to rely on a vendor's audit, then you have to have participated in this. So this is important, and I think this is a smart call on their part. This is essentially going to force some interaction between the vendors and some accountability. And we presented comments to this effect where we stated that there needs to be some clarity about what the relationship is between the employer and the vendor, and what are the employer responsibilities when relying on a vendor's audit. And here they're making it very clear that one responsibility, or at least the one that's articulated here, is that you have to provide data. If your data was not in that bias audit, you can't rely on that. So this is an important one here, and I'm sure people will comment on this, but I think this was actually a pretty smart call. So the published results prior to the use of the AEDT. So now this is talking about what you actually need to put out in regard to this bias audit. So I'm going to read this. Prior to the use of the AEDT, an employer or an employment agency in the city must make the following publicly available to the employment on the employment selection of their website in clear and conspicuous manner. So you got to put on your website the date of the most recent bias audit and a summary of the results, which will include the source and explanation of the data used to conduct the bias audit, and the selection rates and impact ratios for all categories, and the distribution date of the AEDT. So, when have you been using this? The requirements of the subdivision A of the section may be met by an active hyperlink. So you can have a hyperlink to a website containing the results of the summary and distribution date, provided that the link is clearly identified as a link to results of the bias audit. So you can have something that says, click here to get the bias audit results. C, an employer or employment agency must keep the summary of the results and distribution date posted for at least 6 months after the last use in the AEDT for an employment decision. So here, this is kind of new. Actually, I'm not sure if it's new from the last ones or from the original law, but they're basically saying keep that thing around. Even if you stop using it, you got to keep it around for 6 months after. Presumably, that's because some people who might be seeking recourse will want to be able to look at those results. And then there's a bunch of things about candidate notification, which is less relevant for us. We're mostly, in our work, we're focusing on bias audit. So in summary, the new rules are out. So for those of you who missed the beginning, the big announcement was this is getting pushed back. The enforcement of this will be pushed back until April 15th, my birthday. So that gives us significantly more time than January 1st to get this done. And they have published new proposed rules, which I just went through. They look mostly the same as the previous proposed rules. Significant differences are they have removed the term modify from the automated employment decision tool definition. In our opinion, this significantly narrows the scope. Essentially, you have to have a tool that really just with no intervention, no human intervention, takes people out of the candidate pool immediately. So there are tools that do that, but there are a lot of tools that will show everybody, but it will be in a ranked list. So it's unclear if a person can see all of the candidates, and if that score isn't, if the person still has to select that, it seems like it's not going to be in scope. There are other issues with it's really focusing on machine learning. So there are, if it doesn't use machine learning, it doesn't seem to be in scope at all. I think I also have opinions on that. I think that's kind of the wrong way to go, but in any case, it's there. They have a new sense of average score. So previously you could calculate the average score. Now the average score has turned into a scoring rate, which is essentially, what the percentage of a group is above the median. So they sort of have set their own cutoff here, which is the median value of the testing data set that you're using. They made it very clear that independence is required. So an independent auditor has to be somebody who does not work at the employer or the vendor, and they don't have any financial relation. So they haven't used the tool or made the tool. They don't work at the employer or the vendor, and they also don't have a financial relationship. What that means exactly, whether that means sort of the independence that we adhere to, which is the sort of Sarbanes-Oxley / for humanity independence, it's a little bit unclear because it's a very short line in the proposed rules. But what it seems to mean is that you can't be getting money, have some financial ties to this organization separate from the audit. Clearly, I think independent auditors should get paid to do what they do, so it can't mean that. And then they've clarified the relationship between vendors and employers. Namely, vendors appear to be able to do the audit or have the audit done on a vendor level by supplying historical data from the AEDT from multiple employers and employment agencies, give it to an independent auditor, conduct a bias audit, have a summary, and then employers and employment agencies can use that summary. However, they do stipulate that if that is going to happen, you, as the employer and employment agency, had to have contributed to that data. You can't, your data was in the mix, so to speak. And so that's a change. They've clarified this relationship a little bit more. It's clear that vendors can do it. So vendors are probably going to get a little more pressure now to actually get these done, because they are allowed to get them done or have them be done. But they need to be clear. So if you're a vendor and you're talking to your clients, you have to be clear that, yes, we can get this bias audit done. However, if you want to use the summary for that to fulfill your obligations under the law, your data is going to be in the mix. And so there has to be some conversation that happens. Ideally soon. We have 4 months now, roughly, before it comes into effect. So there's time now to get people's data from employers' data into the testing data sets so that they can use that summary to comply. Okay, so what I'm going to do is I'm going to take a look, see if I have any questions. I feel like I've got one. So how do you think the language around independence and bias audits with this law will impact other emerging regulations concerning AI, like the EU AI Act? Is this a signal of what is to come, or do you foresee other future paths regulators might take? And if so, how should organizations prepare? That's a really good question. I think this is going to have an effect on other laws, for sure, in the United States. I think there are a lot of, so DC is considering a law, Colorado is considering laws around insurance, California is considering amendments around employment as well. So a lot of people are considering local laws and potential federal laws that are playing with the idea of these independent audits. Or auditing sometimes it's risk assessment, sometimes it's a bias audit, sometimes it's a combination of both. And they're going to probably look to New York to see, how is this working? Because part of the question is there an ecosystem to sustain this, right? You can't just say everybody has to have an independent audit done if there aren't people to do it, right? And so one of the questions that we're hoping to be part of the conversation is that there is an ecosystem out there of companies that can do these independent audits, can do them in a way that's not going to break the bank, that even small and medium-sized enterprises can pay for it in a rigorous way. And so I think New York making the decision to be explicit about that, not allowing sort of just the independent audits or the independent sort of self-regulation type thing where people just have to do it internally and keep the document, that's going to have an effect on other regulators. And so I think in a way that's going to lean towards, assuming this works and everything doesn't fall down, towards independent auditing be a viable option. Now, for the EU AI Act, they're very explicit about what they're planning on doing. There's going to be quality management systems that companies will need to maintain, and the documentation around those quality management systems. And there will be independent bodies which will do conformity assessments in some cases. In some cases, there won't be it won't have to be independent, and you won't have to have a conformity assessment necessarily. But for high risk systems, likely you will. And so I think that in the EU, I'm not sure whether this will have a huge impact. There's still a lot of wiggle room for the EU AI Act, and there's a lot of room in the standard setting. And so if this seems to work, I think that there will be a market opening up for these kind of assessments. And at the very least, there will be sort of a market for big employers who are procuring tools, AI tools from smaller vendors. I think there might be some pressure, especially if this ecosystem is alive and well, to be getting these sort of assurance audits done to sort of mitigate the risk to the bigger companies when they try to procure these things. Okay, let me see. Anything else? I think that's it. All right, everybody. Thank you for showing up mid holiday break to talk about these new rules. We are going to be back on our regular webinar schedule starting in January again. And so I'll see everybody then. Thank you.